Mr. Engelbrecht in respect of his clients accused 7, 8, 9, 23, 25, 27, and 28. May it please the court. Before I sit down, I will only be here until 11 o'clock. If I may be excused after that. My clients are not party to these proceedings. May it please the court.
Today is we're supposed to do with the matter for the application for separation of trials, my lord. That's the matter which was set down for today.
Good morning, Judge. I appear in person, as does applicants 2 and 3. Mr. Pius Mwatelula as well. That is the first, second, third applicants and second respondent. That would be accused 1, 2, 3, and 6. Or the entities. No, just the application is just, yes, sorry, yes. My entity is accused number 21 and applicant number 10. Yes.
And so you are appearing for the entity.
Yes, that accused number 21. As an applicant, that entity is entity number 10. Okay. Applicant number 10.
And then Mr. Hatuikulipi.
Morning, Judge. Let me just, in terms of today's application, I'm applicant number 2, and the entities is applicant 6, 7, 8, and 9. Yes.
17, accused 17, 18, 19, 20.
And 22 years, correct, Judge.
And the entity is the 9th respondent, my lord. 11. The 11 number.
Yes, Judge, I appear in person. And in this application, I also appear for the entities, which is the 4th applicant and the 5th applicant. Yes.
Yes, for the applicants, we're starting Mr. Shanghala, is it?
Judge, there is another application that I filed with the court. That application is an application in terms of Section 149 of the Criminal Procedure Act. It was filed on the 18th of October 2024, served upon the state at 1, to be precise, 33 minutes after the hour of 1, and all the other respondents in that matter, that is all the other accused persons or their legal representatives, have received.
When you said it was saved on the state, what do you mean?
The document was physically delivered to the Office of the Prosecutor General, and it has been enrolled in the court, in the Registrar's office, before the presiding judge of this trial.
So by state, because remember you are dealing with 149, isn't it?
Indeed.
It requires you to save on who?
The state and all the parties of interest, that is now all the other accused persons.
Isn't it more specific than just the state? What does it say? 149, what does it say?
Should I read it out?
No, just look at it.
Indeed, Judge.
You quote it in your papers, isn't it?
Yes, I do. Section 149 reads as follows. Change of venue in Superior Court after indictment has been lodged. 149.1. A Superior Court may at any time after an indictment has been lodged with the Registrar of the Court and before the date of trial, upon application by the prosecution and after notice to the accused, or upon application by the accused after notice to the prosecution, order that the trial be held at a place within the area of jurisdiction of such court.
My interest is only on who does that section say it must be served, the application.
Upon the state and in the abundance of caution.
What word is used in section 149?
The exact word is after notice to the prosecution.
Yes, to the prosecution.
Yes.
Yes?
So they have received the application.
So you served on the prosecution?
Yes, on the 18th. Their office date stamped receipt of it. At 13:33. The state has not opposed that application. They've not even filed a notice of intention to oppose. In the premises, the application is unopposed.
Well, before we get there, why is this, which matter came before me first?
The matter that came before you first is the separation of trial.
Yes, and how does this one get precedence?
Well, the application itself.
Because when we set this matter down, we set the matter down for the separation of trials, isn't it?
That is correct.
And that's the matter I am to hear today, isn't it?
From the perspective of that application for the separation of trial, that is entirely correct. I take no issue with that. What I was trying to bring to the attention of the court is that in that 149 application, I specifically requested and applied that that matter be heard before the separation of trial. The state received it and did not oppose it. It is thus before the court. Whether it was filed after or before is of no moment. The issue is that the state takes no issue, nor does any other party who potentially has an interest, and I believe they have an interest, despite what the statute says, has indicated that they oppose. In the premise, therefore, that matter is of precedence before the court. But, of course, it is the court's court.
If I were inclined to hear that matter, why can't we hear both matters?
Yes, and if we were to hear both matters, we'd first hear the one that
No,
relates to the
I'm just asking, why shouldn't we hear both matters?
Excuse me, Judge?
Why shouldn't we hear both matters?
I'm not opposed to the matter being heard on the basis of the application that I made. I will have another issue to say about the application when I get to that application. But first, I'm putting before the court the application in terms of Section 149.
You mentioned in your papers that that application, the same relief is before another judge.
I said a similar relief, not the same.
No, my question is the relief sought in the venue application not part of the relief sought in a matter before another judge?
Partly. That is why I made the distinction between same and similar, two different words. But I will explain why they are
before
different.
you explain, do you have the relief, the whatever notice of motion, specifically
In the
dealing
other matter.
in that matter so that I can understand what you are talking about?
Yes. As I get it, I just need to inform you that Justice Mwatelula has indicated that that matter cannot proceed until this court addresses the issue of the Section 149 application and has set down the matter for the 19th of November for hearing in the event that that matter is not, this matter is not dealt with the Section 149. The notice of motion reads as follows.
Not the whole of it, on this particular relief.
Sorry, are you asking in terms of the 149 or the application in the High Court?
The application in that court concerning the change of venue.
Yes. That is the one I want to read the notice of motion for you. My apologies. The notice of motion in that matter, which was filed on the 11th day, which was filed on the 12th day of September, reads as follows. Take notice that the applicants intend to make application to this court on the 11th day of October, 2024.
Now just read the particular point,
Yes.
the relief.
Part A.
Yes.
1, condoning the non-compliance with the forms. Okay, that one I'll leave. 2, interdicting and restraining the fourth respondent, being the Prosecutor General, in terms of Article 25.3 of the Namibian Constitution, from continuing to prosecute the applicants in proceedings of criminal case number 06-2021 in the Oshadonjupa courtroom, wherein applicants are accused persons confined behind a metal burglar bar cage at the courthouse situate within the precincts of the Window Correctional Facility, pending the determination of Part B of this application by the Honorable Court. 3, further and alternative relief.
Just a minute.
Part B.
Just a minute.
Yes, Judge.
In that relief, you are seeking to stop the prosecution from doing what?
Interdicting and restraining the Prosecutor General in terms of Article 25.
Let's just be, let's not always read, let's just talk. You are asking, you want to stop the prosecution from doing what?
Continuing to prosecute us in this facility, in this courtroom, wherein there is a metal burglar bar cage and other causes of complaint, which I was getting to in Part B.
Yes, and then on the...
Then that notice of motion has a Part B and then also an alternative. So let me go now to Part B. Paragraph 4, condoning any non-compliance. Paragraph 5, declaring under Article 25.3 of the Namibian Constitution that the prescripts of a fair trial cannot be met if criminal case number 06-2021 is prosecuted in the Oshadonjupa courtroom as the confinement of applicants as accused persons in an area encircled by the burglar bar cage in that courtroom infringes upon their dignity, the presumption of innocence, and without the furnishings...
What is the relief you are seeking on that particular point? That's all I'm interested in.
That was what I was reading, and I wanted to read it to you so you can see that what you...
Can you be specific, Mr. Shanghala? What relief did you seek in that application?
We sought that the causes of complaint in this courtroom be dealt with. They are the following: the cage with the metal burglar bars. 2, the lack of a workspace table whereupon I can keep my documents, as you can see. 3, lack of electric points. 4, lack of access to the Wi-Fi that is publicly available in courtrooms. 6, access to a lectern that we could use.
Yeah, with all that, what did you want the court to do for you?
To pause that the prosecution doesn't continue herein. Alternatively, and this is where the alternative was going to be, the court directs that the prosecution and proceedings in this case be conducted in another courtroom wherein the impediments of this courtroom are not an issue, and that the matter proceeds whence. So it is in that light, when we engaged with the court, when the matter appeared on the nominated date, that's the 11th of October.
So just to be clear, the court, which is not this court,
Yes.
was asked to stop the prosecution of the trial in this court, right?
Yes.
And secondly, that the trial should not be conducted in this courtroom.
If those are the two issues that I've been able to read out, yes, there are other relief.
No, the others I'm not concerned about, because here we are just concerned about the venue thing. So the court has been asked to decide whether this trial or whatever is entailed by trial continues in this court or in another court, isn't it?
Yes.
And what has the court said?
The court has indicated that the Section 149 application, which is before this very court, be determined so that we see whether it will grant the relief, and the balance of the relief sought in that other application can then be dealt with in light of the fact that this court has made a determination. It's possible. For example, the court says to me, Justice Shafimana Mwatelula says to me, you seek a table, but it is possible that you don't need a table.
All right. My point, Mr. Shanghala, is this. The relief which you appear to be looking for in your application before me is exactly the same relief you sought from the other court.
That is incorrect, Judge. And if I had the time to read out the entirety of the notice of motion, you would see why I use the words same and similar.
No, I have gone with you through the relief sought.
No, we haven't. You
no,
allowed me to
if you want to answer yourself, you can do that. When I ask questions, I want an answer for myself.
Oh, I see.
If you want to say a lot of other things, that's up to you. But when I ask questions, I am asking questions so that I get to understand what I'm dealing with and what decision I'm called upon to make.
As it pleases the court.
Now, just to go over it again, is it correct that in that other court, you sought to stop the prosecution of the trial in this court?
Amongst others, yes.
So you sought to stop the prosecution in this courtroom, correct?
Amongst other relief, yes.
Yes, among others. I'm not concerned with the others now. Then secondly, you thought that the venue for the trial must be another courtroom other than this courtroom.
In the alternative, yes.
In the main?
In the alternative, that the other relief is not granted or cannot be granted, then that the court directs that this prosecution takes place in another courtroom.
So, has the judge decided those issues?
No, the judge has indicated, as I was explaining to you, that some of the relief that I seek might be granted by an order of this court in the Section 149 application, such as the tables.
Do we have anything from the judge?
No. In fact, this morning when I tried to check on the e-justice platform, no court order has been uploaded as yet. I do have the court order of previous when it was heard for the 7th, but I don't have the one where he has postponed the matter to the 12th. Sorry, 19th of November.
The impression I have, which I must be dissuaded, is that the relief you are seeking is the relief you sought before Judge Utele, and unless the judge has, for some reason, declined formally to deal with that application, then I would start to look at it myself. But we can't have two courts dealing with essentially the same relief on this particular point.
I'm aware, Judge, that you have that perception, and I've tried strenuously to try and dissuade you. But as you rightly indicated, you will ask what you want to hear and only make a determination.
You see, I don't have anything from the judge. I don't have any record of what transpired before the judge, what order he made. I don't know.
Yes.
And I would rather, because my appreciation of court proceedings is that you have to make an order, whatever you are doing. If it is informal, that remains at that level. But if it is a formal determination of an issue, an order has to be made.
Regrettably, I can only promise you that I will try, if we at some point recess for a tea or coffee as it is in your office, I will be able to ask your clerk to request from her other colleague if that court order can be uploaded so that we can consider it. In the meantime, Judge, I wanted to inform you that I have been subpoenaed to testify at 2 o'clock in a matter relating to my previous portfolio as Minister of Justice in one of the courts, an extradition
in which
matter.
Court?
An extradition matter, which is before the court, where I've been subpoenaed. I had testified before. It continues today at 2 o'clock. It's just...
And they postponed it, knowing very well that this matter was before me on the 11th.
Yes, I indicated to the court, and then I told the court that it starts at 10 o'clock, and then the judicial officer then postponed it to 2 o'clock. If I am unable to appear there, I will possibly have to request the prosecutorial colleagues there to communicate with their colleague there so that a warrant of arrest is not issued for me.
Well, now, just to, because I would want the state to respond to these preliminary issues we have been discussing. But I want to know, what specific relief do you want in relation to the change of venue? That this court moves from where to where?
I indicated that there are 4 court buildings in Windhoek.
To which courthouse do you want this court to move to?
No, Judge. With respect, Judge, you can't ask me that question. It's not in my province to make that determination. What I did do is put to the court the options that are available. And that was what I was trying to tell you, that there are 4 courtrooms in the district of Windhoek, in the main division here. This courthouse, the SADC Tribunal building, the main division itself, and the one on Shon Line, which I inaugurated, the commercial court.
Who allocates courts?
That is an issue done between the head of court and the registrar.
So assuming I said that we can move to another court, and the head of court says there's no room there.
The head of court would be getting a direction from court, a court order, and would have to execute an administrative function. So the head of court exercises judicial and administrative functions. That's the administrative part of that head
So
of court
why is
function.
the head of court not cited here, so that he's able to say there's a courtroom available
Not cited where, Judge?
as a party to these proceedings?
These proceedings, the criminal procedure.
Yes.
Is that possible, Judge? I was not aware that it's
I
possible.
don't know, because the person who determines where a court sits is someone else other than myself. I can't say in good conscience, say, just as an example, we move and we are going to sit in the main division. Then we go there, we are told, there's no room for you here. We gave you that court. What I'm trying to say, Mr. Shanghala, is this. Without overburdening the issue, my experience on the bench has always been that I, as a judge, walk into a courtroom given to me by those who set out these issues, who determine those issues. If it is in a backyard and they say, this is your courtroom, I'll walk in there and do what I'm supposed to do. As a judge, I can't be involved. I don't have that experience to be involved in administration, go to this court because this one doesn't have these facilities. I'm not very certain that is one of the functions of a judge. The judge determines an issue before him. It may include what you are asking for now, but without citing the responsible authorities who will be able to say, your judgment can be a brutum fulmen because there is no other courtroom other than the one we gave you. So, that is my experience. And I'm wondering what the attitude of the, you call him the judge president, isn't the one who is responsible for allocating courtrooms? Is the judge president?
I would believe so.
So what is his position with respect to all this?
Right. Judge, you've said quite a mouthful. Allow me to just take it from the top so that I can respond to you adequately. When we appeared before Justice Mwatelula in the matter that relates now to the application for the issues around the inadequacy of this court to be dealt with, this courtroom, he also indicated, Meramotu, that there's a potential issue of non-joinder in that application of the judge president. And I responded to that issue of non-joinder as follows. There is a difference between the complaint I make in that application and the complaint he perceives I ought to make. I do not make the application against the person who is in charge with the functions of the court in the court. I made the application in respect of the owners of the court building. The court building is owned by the state through the Ministry of Works, caretaken of by the Ministry of Justice. That is why, in the Office of the Judiciary Act, the Minister of Justice is responsible for capital projects. That office bearer is a party to that litigation. What I have
is he a party to this one?
I'm coming to that.
No, answer me.
I've heard what you said.
Is he a party to this one?
To this application, the 149 that is before you, the Minister of Justice is not and cannot be, because the Criminal Procedure Act does not seem to indicate in Section 149 that other than the state, there's any other party that ought to be given notice and to become participant there.
But you cited other parties whom you perceive have got an interest.
No, I did not. I took the criminal case citations, put them before court, and the first thing I raised was for the court to clarify how the application should be made. Why did I do that? Because the prosecution here has time and again said, we are importing civil trial, civil stream matters into the criminal trial. So if you rely on the Criminal Procedure Act, just rely on the Criminal Procedure Act. So I put it before the court for a determination going forward, noting that there will be many interlocutories, and those interlocutories need to be guided somehow, and that the court has the powers to regulate its own procedures. So if you would make a determination pleasing the court, that would then give us guidance how to go forward. If, for instance, you were to say, in that court order, this matter should therefore be re-enrolled with those parties that are relevant, both those who are the owners of the building and those who are responsible for what happens in the court, to be parties to this matter, I will happily do that. But as it stands, from my construction of the statute and the rules, that is the application before court. And that application must be addressed by court. Now, back to that other application and why it's different. I then indicated to the judge that if I have the executive director who exercises the functions under the Office of the Judiciary Act of 2015, the registrar, the prosecutor general, and the minister of justice, in that application, I thought that I had sufficiently covered the basis and covered all the parties of interest. For sure, the registrar exercises functions, but under the direction and control of the head of court. The same with the executive director. In fact, in his case, it's much more clearer. It's articulated in the Constitution, and I would know so. Now, why the judge, and I'm happy we're having this conversation, your experience on the bench and my experience from administration of justice. My understanding is this, that in terms of Article 8.2, if I complain of a constitutional right violation, and particularly what Article 8.2 says, and there's a word I'd like to refer the judge to. It says, in any judicial proceedings or in other proceedings before an organ of the state and during the enforcement of a penalty, respect for human dignity shall be guaranteed. So, to the extent that the judge is perhaps apprehensive about what to do when in the court, and it explains now why when I've made and I've gestured and held the burglar bars and said, make an order, remove them, you weren't willing to do so, is because perhaps you do not understand that you have those powers. I believe that as the presiding judicial officer in a matter, according to Article 8.2 as I read you, if my human right is being infringed, you have not only the power, nay, you have the duty to enforce my fundamental right. So if you make a court order to the extent that this court is constitutionally non-compliant of the issues that I've raised, that court order would have to be implemented administratively by those who administer it. The function of ensuring the courts are attended to, etc. Judges are allocated to cases. If it means it's the judge president, it does not mean that because the judge president is the judge president, a court order cannot be made against him. I can tell you, for instance, I know as a fact that he was married and divorced. There was a court order that divorced him, and he's still the judge president. So the judge president is subject to court orders like anybody else. That is my submission in respect to the concern that I cannot make the court order. Did the
registrar say in that other matter, did the registrar say their courts are available?
The registrar says a lot of things.
Did she say whether there is a court available or not?
The one thing she does not say is that this court is available for you. What she says And what they say is that they require 120 days to get quotations and commence the works that would be required to solve the causes of action that I have raised in the
Does she
application.
say that before the 120 days there is a courtroom available for this matter?
No, she doesn't say that, which is why I then make the application to say perhaps if there's a court order that would then make it available. Failing which, the matter has to wait for 120 days, which they seek, so that they can sort out themselves for the matter to proceed.
All right. Those are by way of preliminary issues. Let me hear from the state. The prosecution, Mr. You received this application?
Yes, my lord.
Yes?
My lord, we are in this courtroom not by our decision. We were told that this matter will be tried in this courtroom, and we were parties to this matter. We walked to this courtroom for trial. In the same vein, we were not consulted when this court venue was decided in the first place, and we are amenable to go to any venue which the court would decide the matter will be tried, as long as it is somewhere where the state and its witness can be accommodated, my lord. We have not.
So how does this judge know what fulfills your requirements? I have to go around looking for courtrooms and seeing which one has got the facilities.
Maybe if we go to another court which also is not suitable for the state, we'll make the similar application like Mr. Shanghala, but we are happy with this court venue. We don't make decisions about court venues, my lord. So that's why the state did not oppose.
The state doesn't oppose what?
The prosecution.
The prosecution doesn't oppose what?
You read the application because there's no order which is being sought against the prosecution. Which the issue of allocating the court venue is not for the prosecution.
Whose is it?
My lord, the state really did not take its time to do that research, because last time we were told that we saw on the court roll that this matter is being tried in Ochochozupa court, and we came here. We didn't ask.
So is the prosecutor general or the prosecution, you don't know who told you to come here?
We are not in charge of the courts, my lord.
So just as a matter of interest, who allocates courts in this jurisdiction? Who says this court will hear this matter there, this one in Oshakati, this one in the main division, this one there, with the physical infrastructure? Who says that?
My lord, about whether the matter appears in Oshakati or in this courtroom, it depends in which court the matter was
no,
issued.
I'm not talking about the area of jurisdiction. I'm simply saying the actual courtroom. Who decides?
The last time I checked, my lord, it was the registrar. I think we're in consultations with the judge president.
So are you familiar with the proceedings before Uteleje?
No, my lord. We did not take part in those proceedings.
So you don't even know about that?
I was aware that there was...
No, not the awareness. You don't know really what's happening in that matter, is it not?
That's correct, my lord.
But after reading this application, what is this not the same issue?
It is, my lord. And it is the same issues which are being raised.
So what does it mean? I mean, one relief is sought in one court, another relief is sought, the same relief is sought in another court. How do we function?
My lord, the rule is that litigants should not go court fishing, my lord. you can't seek the same relief between two courts, whether they're the same jurisdiction or not the same jurisdiction. That cannot be done, my lord. You have to stick to one court.
I notice you are reluctant to say you allocate courtrooms. You don't want to get involved in that. Your business, just you are told you are going to courtroom number so you go, isn't it?
Yes, we are parties, my lord, to litigation. We just go to the court.
And you are not prepared to say who allocates courtrooms?
My lord, we really, what we are saying is off record, because really we don't know the procedure, the process involved in how courtrooms are allocated, my lord. We are not consulted as a state, as a prosecution.
Well, is there anything else you wish to say?
Nothing, my lord.
And if we can hear this application here, why can't we hear the main application here as well?
My lord, the state is ready to proceed in this courtroom. The state never complained about this courtroom, my lord.
Right, okay. Mr. Shanghala.
Judge, thank you very much for the opportunity to reply. Judge, when an application is made, just 4 short things to reply to Mr. Bernardt Esau. When an application is made, as in this case, an application was made, they were served upon them. If they don't take issue with the matter, they ought to file a notice to abide by the court's ruling. They have not done so.
What if they have nothing to do with it?
Well, then we take the reasoning you had taken in the recusal matter, that if a party has been served, and in the recusal, remember, we were not even served. If a party has not entered any appearance, then they are happy. That is what you said. Please don't make me read the record.
They are saying they are happy with this court and with whatever else is decided.
Yes, that is all they should have said. It should have ended there.
No, but they have nothing to do with it.
No, Judge. They went on to say things which are the next 3 things I want to respond to.
No, I'm saying on paper they said nothing.
Yes, which means that they're happy. And it should have ended there.
No, they may not be happy, but they said nothing.
No. If they wanted to say... I'm using your reasoning. This court cannot...
I'm not sure you are, but
No,
anyway, you can carry on.
Judge,
You
I will
look,
quote
you
you.
can convince yourself that you are using my reasoning.
Should I quote what you said previously?
It doesn't matter. What I'm simply saying is, if you arrogate yourself an understanding of my reasoning, it's well and fine. I have my understanding of my reasoning as well.
Well, fine. Let me move on, Judge. I don't want to get to a point where I have to read to you what you said. Anyway, I am not caught fishing. I want to make that very clear. I am not caught fishing. If there's anything, I'm trying to request this court to uphold principles derived from the Constitution, and not just anywhere in the Constitution, the heart of the Constitution, Chapter 3. The reason why I do not want to be tried in this court in its current configuration, those issues I will address in that application, the 149 application. Now, Mr. Bernardt Esau says, no, we just stand up and go to court. That cannot be true. And it cannot be true since before 1977. Not because that's the year I was born, but because that's the year the current CPA was promulgated. Section 149 has not been amended since. From the 55 Act, it hasn't been amended. And it says, a superior court may at any time after the indictment has been lodged with the registrar of that court and before the date of trial, upon application by the prosecution. So the prosecutor has an interest in the venue. He has always had an interest in the venue.
Is this before, it says, and before what?
Before trial.
Is this before trial?
It says here that at any time after an indictment has been lodged with the registrar of the, and before the trial, before the date of trial. My understanding, and we've canvassed this issue with you before, in terms of section 11, if I'm not mistaken, 106, 105, it reads, the charge shall be put to the accused by the prosecutor before the trial of the accused is commenced. I would say we are squarely within 105. Therefore, it answers, a fortiori, your question. We are before trial. This is before trial. So the prosecutor could have applied. I applied. The fourth issue, that's the third point after the first issue. Why not try the main matter here? I am hesitant to answer
not
that
main
question.
matter. I didn't talk of the main matter.
The criminal matter.
No, the application for separation. Because I'm not certain that we need more than 2 hours to deal with the application for separation, do we?
Well, because
if we can hear one application here, why can't we hear the next?
Yeah, in sequence, then should I get into the application then of 149? And then we can move on to the next, or how?
In sequence of what?
In sequence.
Remember, I have not been granted the agents of this matter.
Yes, that is why I'm saying.
Yeah, so the sequence is the separation of trial was the matter we set down for today. This one was an application that came later, and on apparent agents, isn't it?
Yes.
And have you been granted that agency?
No, the court has not requested me to address it on the urgency of the matter as yet, and therefore has not yet made a determination on it. Hence, I was asking, would we go about it in that sequence?
If you want to deal with the agents of the venue application, you can do it right now.
All right.
What the agents of it?
Another reason that I hadn't had in mind at the time when I made the application has now come to the fore. That is, that the High Court in the other application, and perhaps just for the record, I need to read the number of that application into the record. HC-MD-CIV-MOT-GEN-2024/00465 before Justice Mwatelula has been postponed to the 19th of November at 10, precisely to determine outstanding matters that wouldn't have been addressed by this 149 application. That is one reason.
I don't have a court intimation to that, except from you.
Correct. I unfortunately also do not have a court order, but as I indicated to the judge, I will commit to try and obtain it possibly today or tomorrow and file it with the court whenever I obtain it. The other reason is this, and these are the reasons that are in that application, that the state has actually conceded that this courtroom is not constitutionally compliant in respect of the causes of complaint that I've put before.
The problem is I don't have what concessions they made in that other matter. Do I?
The first one.
Do I have those concessions?
In the application, you do. In the Section 149 application, they are there. But
concession by who?
By the state.
But the state hasn't filed anything.
No. You see, Mr. Marandeza says to us, Judge, that he's not even aware of that application. In that application, the representative, the government attorney.
But what you're saying, Mr. Shanghala,
Yes.
you may be very correct, but I don't have that application before me to see that the state actually made certain concessions.
Well, the one you can see, they've removed the burglar bars.
I don't know whether it was as a result of a concession.
I'm telling you that, and I can read from their affidavit of the executive director or the registrar, that they removed them 3 days after we filed the application.
That was good.
Fine and well. They didn't solve the problem, obviously, but because they've made concessions and because they request 120 days to get their house in order, we requested 90 days. We said they should file a report within 90 days so that this case can continue. They said, no, 90 days is too little. Give us 120 days. And we said, okay, fine. Take your 120
All right,
days.
Mr. Shanghala, we can go on and on about this. Did the registrar say there's a court available in that matter? Did she say there's a court available or not?
She didn't say that. We didn't ask her to say that. We asked her to address the issues of this court.
Right. According to your papers, the paragraph 11.6, what does she say there?
Excuse me, Judge, I didn't hear you.
The papers you attached to your application, paragraph 11.6.
That's the 149 application.
Yes, being the registrar's response, what does she say?
Paragraph 11.
Mm-hmm.
Get it there.
11.6.
Of the affidavit, the 14-page affidavit.
I don't know whether it's 14 page, well, it's 6 page. The one you attached.
Okay, let me go to the attachments. The affidavit itself of the registrar. Oh, okay, I see. Yes. Should I read that?
Yes, you can read it.
Add paragraphs 134 to 141 thereof. I wish to place on record.
No, I said 11.6 only.
It is also important to note that currently there are 70 criminal trials and 4,000 civil trials pending in the High Court, and as a result, the High Court currently has severe constraints with the number of courtrooms, chambers, offices, and storage space available, and therefore there is no luxury in choosing courtrooms, as one should use the available facilities.
Mm-hmm.
You wanted me to read that?
Yes.
Should I also perhaps read you my reply to that? Maybe then it is fair.
Well, before you go, what is she saying there?
No, Judge, what I'm saying is...
Please, we'll come to that point. I have said, what is the registrar saying there?
She said what I just read out. And
which is?
I can repeat it. She says...
If you want to conduct yourself that way, look, when I ask questions, Mrs. Shanghala,
yes,
you better answer them directly.
Yes.
When I ask questions, I would appreciate a direct answer to my questions.
Yes, I thought it's very clear. She's saying that you are looking for luxury. That is the principal issue I take out of this issue. And I've responded to that particular issue. And it would only be fair if you read the one, you should read the other.
Why do you think I haven't read it?
No, I didn't say you didn't read it.
I have
but what
read
I
it.
did is I read it out in court. And
I said I have read your response to that.
okay. So then there shouldn't be a need to address this issue because I think I've dealt with it, with this issue. I've put it to bed. That this is not a luxury. This is a constitutional prescript.
He said there's no luxury of choosing courtrooms.
What she's basically saying is, if I put you in a courtroom that is not compliant with Article 8.2, stuff it, take it, because I have, how many? 4,000 civil trials. And I say to her, that is utter rubbish, because the Constitution is what you should be utilizing. She cannot be heard to be saying such things as an officer of court. Unbelievable.
Well, so, and the...
That is why when I started...
And
excuse me?
the Mr. Kandandu,
Yes.
did he say that there are courtrooms available?
No, Mr. Kandandu speaks more to the issue of the capital nature, the capital projects.
No, isn't your application is to have a courtroom now, isn't it?
Excuse me, Judge?
Your application is for a courtroom for this venue to be changed so that we go into a courtroom now to
No, I
hear
didn't say
the...
that. No, Judge. That is not, that doesn't characterize my application correctly. My application is that in the event that, while that matter is being determined, that this application and the application for separation of trials can and should continue in a courtroom other than this one. And that is the 149 that I brought here.
That is the application we are supposed to hear today, isn't it?
Yes.
You want it to continue in another courtroom?
If it cannot continue today, when it continues, it should continue in another courtroom.
You don't want it to be heard in this courtroom?
Yes, and there are reasons why I don't want it heard in this courtroom. Because the reasons are it's not constitutionally compliant.
All right.
Mr. Kandandu, by the way, Judge.
Anything else on this venue application?
Yes, Judge. Mr. Kandandu, just on your issue there, Mr. Kandandu says he wants to renovate all the other courtrooms across the country so that they become removed of that cause of action. He says so. And that he says he has obtained a quotation of some 600,000. He needs 120 days. That's principally the person who says that. Now, the reason, yes, so that is thus far my issue in my submissions on the urgency of this 149 application.
What is the urgency?
The urgency I indicated first is that there is now a court date set on the 19th of November by Justice Mwatelula.
No, I mean the urgency of your application for change of venue. What is urgent about it?
Yes. This application is, it seems, a sine qua non to the consideration of another application, the one that I read out, the court number 00465 before the High Court. That matter is set down on the 19th of November. This matter is linked to the very merits of the other matter, but this only seeks a venue change, not the resolution of the issues being determined in that other matter. That is the difference.
About
Excuse me, Judge?
the urgency of this application. What is urgent about it? We have been in this court since last year, isn't it?
Yes.
So what is urgent about change of venue?
Well, since last year, I've been asking the court, with the greatest respect, to make an order for these burglar bars to be removed and for the other issues to be addressed. But the court hasn't been making that order.
I don't make orders out of, I've said that time and time again, I don't make orders arising from requests, proposals. I make orders on the basis of an application.
I thought that we had clarified this issue with the court before.
Yes.
That an application can also be made on one's feet. I did not understand it.
Yes,
And
if you specify that you are making an application.
Yes, and that is why when I consider what is in the CPA, they don't determine necessarily how an application should be made.
If you have to formally rise and say, I wish to make the following application.
Okay, so you see, we are now back to, well, never mind. The issue is this, Judge. If this court continues to determine matters related to the trial, I believe that I will be prejudiced because my rights are
Now let's deal with one point at a time, Mr. Shanghala. What is urgent about this application for change of venue?
That is what I was responding to, Judge.
Yeah, but if you go in circles, then I don't follow you. What is the agency? How does the agency arise? We have been in this court since last year, and all these things have been talked about here and there. What is the agency now that we want to deal with the separation application?
Because the judge said, bring an application and cite the correct parties. That is what you said to me last time. I therefore brought the application.
Yeah, but you brought it asking for urgent relief,
Yes,
and I'm saying what is urgent about it?
Because, Judge, you said, I don't recognize these things that you just complained. And you've been saying it, and I've been repeating. You've been saying it. Now, with the intent to make sure that the process does not continue, I can only bring it on an urgent basis so that it doesn't continue. That is why I thought it would be determined first before anything else. I did exactly what you said I must do.
Is anything else?
Yes, Judge. I've also put before the court in that matter a Rule 94 notice for the state to admit certain facts, those concessions.
I mean, which court?
The court that is hearing the matter 00465, also an urgent application.
Which court is that? The Utele court?
Yes, Judge. That Rule 94.
No, deal with those matters before Utele, with Judge Utele, right? Yes. I can just be told there's this other matter dealing with all these things in another courtroom. I don't even have those papers here.
Yes.
I can't work like that.
No,
if you have put a matter before a different court, you deal with that matter to its end.
Point well taken.
Yes.
I think that is fair. What I wanted to tell the judge is that the discrepancy here is that in that court, the prosecutor general is allegedly represented by the government attorney. And I use the word allegedly deliberately because there's no confirmatory affidavit from her. But today, as we hear, the prosecutor general is saying through the prosecutor that they're not aware of that matter. Fine and well. The issue then, Judge, would be what I placed in the application, the 149, is how do we determine, how do we deal with these interlocutories going forward, particularly when they require, as you indicate, perhaps the involvement, the joinder of other parties, and the rules and how they apply.
I can give you a very short answer to that.
Yes, Judge.
As a judge, I don't give advice about how people get to deal with their matters or how they make applications or in terms of what rules. A party makes his application to court, the court decides his application as presented to it. You make your application. If it is a competent application, it will be entertained. If it is an incompetent application, it will be dismissed. The court doesn't go about telling you or the prosecution, oh, if you want to make this application, do it that way. No. This court will deal with applications that are placed before it and decide that those applications on the basis of the law.
Quite right. No, Judge, I'm with you on that. You've made that point in the Rule 32.
So there's no point saying we want to know how we bring these interlocutors. Bring your interlocutors. If they are competent, they will be decided. If they are incompetent, they will be dismissed or struck out.
Quite right.
Yes.
And that is why what I said to you now is not just something that I'm saying. I'm saying in my pleadings, I make that point, and that point would then require determination by the court. Because as we understand, the state is happy. They're quiet, they're happy. According to the principle that you've established, if you're silent, you are happy. So they are happy. I then raise that issue, and when you make your ruling or judgment,
my concern, as I've said, is just two issues.
Yeah.
One, the matter is before Utele J.
Yes.
He must decide that matter. If he's not deciding it, he tell you or the parties why he's not deciding that matter, and we take it up from there. I can't have the same relief before one judge and another relief before me, the same relief before me. You have asked for a change of venue and other things before the other court. They must decide that matter. I have a feeling that someone must be responsible for allocating courtrooms to me as a judge. That person must be cited so that he tells us the availability. You can't order government to say provide a courtroom when there is no courtroom. I don't see that as happening. There are certain kind of mandatory interdicts which may not be made against the state, in the sense that if there's nothing, there's nothing. And the registrar, in a sense, they said there are no other courtrooms available.
I'm happy to address those issues in that court.
The point of the matter is there are two issues which exercise my mind.
Yeah.
First is the fact that the matter is before Utele J. Secondly, is that the parties who must tell us where we go. I can say we go to 10 building today, and I'm told there's no room for you here, and I go around town, I say, all right, let's go to the main high court. I'm told, no, there's no courtroom for you here.
Okay.
What am I trying to do? Someone must tell us that, yes, an alternative courtroom is available or is not available. Then we make a decision.
Yes. I think the judge has the powers to request the attendance of whichever person was responsible for that.
No, the person comes to court if he's served. Whoever is the rightful party, if that person receives court papers, then he will come. And
yes.
If he doesn't come, then an appropriate order will be made if it can be made.
That's one way to look at it. The other way to look at it is from an evidentiary perspective, to say that if evidence is required before court and in the motion proceedings, either the court dismisses the matter for lack of evidence or calls for testimonies to be presented. Nonetheless, Judge Mwatelula has indicated, and I know you don't have the order here, but that the alternative issue should be dealt with. But he has indicated that if that is not determined, he will then deal with it on the 12th. Another issue which the parties have agreed would be determined by this court is the issue separate, because when we showed him in the papers that this court has granted us the use of Wi-Fi and the internet is being sorted out at the facility, the application in respect of Wi-Fi in this courtroom, the parties agreed that it would be dealt with by this court, not that court. Interestingly, though, when that matter was called, we came here with Justice Mwatelula and had to relocate to another courtroom also for various reasons. But anyway, Judge, I think I have made the presentation. The 149 is before court, and I'm in the court's hands.
Mr. Shanghala, just one last question. We have heard the venue application here. is there any reason why we can't hear the separation of trial application now?
Thank you, Judge. I'd like to address that particular issue. And it is what is at the crux, at the heart of the application in the 149 and before the other court, the Mwatelula court. And that is that I'm unable to conduct my defense if we continue in this courtroom.
No, I'm talking about not the trial. We haven't come to the trial as yet. I'm talking about the application for separation of trial, which is on paper.
Yes, sorry.
I mean, in that application, I suppose you would need an hour, or no, not even an hour, 45 minutes. 45 minutes to make your presentation, the answer, and we're done.
I meant my application, Judge. Sorry, I meant my application. And it really relates to what Justice Mwatelula said.
Please, without a judgment from the other judge, I'm sorry, I don't want all that. I can't repeat and repeat. If the judge wrote something, we'll look at his judgment, we'll understand what he said and what orders he made. If there are no orders before me and a judgment by another judge, I can't just take anything that is said about what he said.
No, I wasn't presenting this, what I'm about to say, as something that should be binding upon you. What I was trying to say is, to answer your question, is there any reason why we can't conduct the separation of trial application in here? Mm-hmm. So what Justice Mwatelula had said to me surprised me. Because when I made remarks to him, he said, but listen, when you are making an application and you are undefended in a criminal matter, you're undefended, you're self-representing, you're making an application, you're not supposed to sit in that cage. You're supposed to sit there where the lawyers are. In fact, the very first day when he walked into the court, I was standing here, and he says, Mr. Shanghala, you are an applicant, come here. And then I had to move myself to where Mr. Marondeza is, and Mr. Ilovu went to stand over there. So I was then of the view that, perhaps he was of the view that if we presented to court an application, you would...
But who has stopped you from sitting there?
I am in detention, Judge.
I don't know. You stand up, you make your presentation from there. Has anyone said you don't come to the bar to make your presentation?
Well, what I know is that I've made a number of applications from here, and the judge has not once invited me to take up...
Why should I invite you if you want to make your case from there?
No, Judge. It doesn't work like that. What works
it works the way you think?
No. What I was going to explain how it works. How it works is...
Mr. Shanghala, may I just... How long did you practice the law?
No, I was not a courtroom lawyer.
I understand.
Yeah. So the point I'm making is this, Judge, that my understanding is that when you are in detention, you are taken where those people in whose custody you are determined. They bring me here. Then they stand guard there, and there's one outside there. That is the practice. So I was very surprised when Justice Mwatelula said that, which would then mean that if that were to be the case, and I know you said there's no judgment and whatever, then it would obviate the need for that order in respect of me having a workspace to put documents on, a table to work on.
Who has stopped you coming there, Mr. Shanghala?
I will address that just now. Let me just finish the train of thought, Judge.
Because if I think you are not saying much of relevance to the issues I'm concerned with, I have to stop you. I said, who stopped you from coming there and present your case?
My answer is allegorical, because had I been invited or had I been directed otherwise, taking into account my handicap of not having been a courtroom practicing lawyer by the judge of such vast experience, I probably would not have brought this application.
All right. When we hear the application for separation, jump and sit there, Mr. Chairman. You can come and make your presentation from there. If you want to make it from there, I'm quite happy.
I'm not happy to make it from here. I'm not happy to even sit here. As I had requested a chair,
I've given you the options.
Excuse
I
me,
said
Judge?
you can, when you make your presentation on the application for separation of trials, you are free to come there. You are free to remain there.
Thank you, Judge. However, Judge, that addresses only one issue, and that is now where I say there was a similarity and the sameness. So, why I believe, so would the judge be amenable to a short adjournment then, so that I may be able to relocate, so that we can continue the 149 issues? I feel uncomfortable here. I've made that very
149
clear.
issues, what again about them?
Excuse me, Judge?
149 issues, what about them again?
Oh, okay. That discussion is closed.
Well,
Okay, thank you.
is it not closed?
No, I'm happy it's closed. I'm happy it's closed. I thought we were still in the 149.
Right.
Because you said
The last question was simply that the application for separation of trials is not going to take us 45 minutes, and I can allocate time to you, 45 minutes, and we are done. And there's no reason why we can't hear that application now. We have heard one application in this courtroom, we'll hear the next one in this courtroom, and then I'll decide the issues.
I am in the court's hands.
Yes.
Would the court allow for an adjournment so that I may relocate, so as the 4 applicants can relocate to where you've graciously invited us to?
What do you mean applicants?
There are 4 applicants.
Well, I'm giving the opportunity. The applicant who is talking will be allowed to come over there and make a presentation.
Yes,
Then the next applicant, if he's talking, he will come there and make his presentation.
Okay, we go, then we come back. Go, then we come back.
It doesn't matter to me.
Okay, all right. So,
We
may I
adjourn for
relocate?
10 minutes.
Thank you, Judge.
or are they now 3? The application for change of venue, we've dealt with that. We hear this application for separation of trials, and then I'll make my decision.
Yes, Judge.
Now, there are preliminary issues raised. Would you want to address them first, or Mr.
Well,
Marondezi?
Judge, I just wanted to say that in making your determination, Judge, it just slipped my mind, as you had asked me last time. Just if you can just file it away. Sorry.
Sorry?
I had forgotten to say this to you, Judge, that the inviolability that I complain of, this is why we needed to move out of the courtroom. The inviolability remains.
Which one are you dealing with now?
No, I'm saying, before we broke for the 10 minutes, I had forgotten to say something, and I just wanted to say it so that you can take it into account.
Reopen things.
No, I don't want you to reopen
Yes.
it. What I was saying is that I didn't express it clearly. I was saying that the inviolability of Article 8, or Sub-Article 2, in judicial proceedings remains even in the consideration of these applications, that those unconstitutional issues are now happening to those people who are sitting there, and that some of those people are applicants. That's all I wanted to say, that the court can take that into account in its calculus as it makes its determinations. The issue of the preliminary matter raised by Mr. Marondezi, perhaps he can raise it, or I can simply just start to address it, and then in answer he comes and deals with it. I don't know how the court...
Well, I would suppose let the party who has raised the preliminary issue start.
As it is.
As it please the Lord, my Lord. My Lord, it was brought to the attention of the state that an order had been granted in favor for the applicants, in which they've been granted permission to cite this honorable court in their intended application to challenge the appointment of this court, that it is unconstitutional. I briefly off-recorded a discussion with the applicant about the whereabouts of his application. He said he had filed it on Friday. However, there was some technical error with the filing, and he could not give me a copy of that application.
Is it filed?
He said he filed it on Friday, but there was some technical error with the filing. I have not seen the application. We have not seen the application.
Mm-hmm.
My Lord,
He said he filed when? Friday?
yes, that's what he informed me.
Friday, the date was?
The 8th of October. Oh, 8th of November, my Lord. I don't want this year to end.
Mm-hmm.
The state has not yet seen that application, my Lord. But the gist of the matter is that you filed an application for permission to cite this honorable court in that application in the High Court, and it was supported by an affidavit, which he gave reasons. And for the court to have granted that application, the court might have considered that the application had merit for some other reasons for him to cite this application. Now, my Lord, the issue is, if the applicants are of the belief that this court is not constitutionally constituted, and this court proceeds to hear applications pertaining to this matter, the very same matter which the applicants don't want it to preside over, in the unlikely event that they succeed in their application, then needless to say, my Lord, that would have wasted enormous resources and time by going through these motions, my Lord. So that's why in the heads of arguments we said they should make their point clear. They've not.
Now, what is your submission on that point, Mr.?
He should make a decision, my Lord. The application made. Are they proceeding with that application, or we proceed with the court as it is constituted?
No, from what you are saying, they have made the application for the removal of the charge, isn't it?
Yes.
We must assume they are pursuing it. They are also making an application.
If they are pursuing it, my Lord, then the simple point is that the logical thing is they should conclude that that application should run its course, and we know whether this court should proceed or not proceed with the hearing of the matter. It's not necessary for us to go through these motions, which at the end of the day.
Just a minute. What is your concrete submission?
Submission is that, my Lord, it will be prudent for us to wait for the outcome of that application. To avoid wasting the resources, both financial and time, my Lord. And if you proceed, we might, by the time that matter is concluded, we might have led one or two witnesses.
You mean not proceed with what?
With the trial itself. This application and the trial.
Let's start to the first thing first. Are you also submitting that this application for separation of trial must not be proceeded with?
My Lord, why would they want a court they believe is?
No, let's leave them aside. That's their case. What is the state case? You are the one who raises.
Yes, my Lord. The position of the state is that this application for separation of trial should not proceed, my Lord. Because if they succeed
Just
in
a minute. Until what? It must not proceed until what?
Until the application to challenge the appointment of this court is finalized.
Yes.
My Lord, because if they succeed, whatever this court would have done will become a nullity. So we'll have to start again.
And if they don't?
If they don't succeed, fair and fine, my Lord. But unfortunately, is that the litigant who has been, they have a right to pursue whatever application they have, which has the implications on the outcome of this matter. Those factors must be decided first, my Lord. If it's going to have negative implications of this matter, whatever implications it's going to have, that should be decided first, my Lord. That's the furthest we can take with that submission, because we raised that premier position point. It was just an inquiry from them, really, what do they want to be done with this matter. They are pursuing this application on that end, and at the same time they are pursuing this application before the same honorable court, my Lord. The second point, my lord, is that
Now, so you are saying, just to understand this, this submission, you are saying that because an application has been filed with the court challenging the constitutionality of the appointment of the presiding judge, that judge must not do anything anymore until that matter is decided. That's in substance what you are saying, isn't it?
what we are saying is it would be better to err on the side of caution, my lord. Yes. That's the submission.
Erring on the side of caution means stop these proceedings until that matter is decided.
That's our submissions, in short, my lord.
Why is it not a correct approach that this court continues until it is told that it is not properly constituted? What's wrong with that? Why is the state, you say it's prudence, resources?
My lord, if we continue, depending how far would we have gone, if this court is told to stop, it means everything has to start de novo. We have to look at the resources which would have been put, resources and time which would have been put in the handling of this matter, my lord. And either way, it will be prejudicial to all the parties.
All right. So how long do you anticipate it will take?
My lord, applications in civil matters generally don't take that long, my lord. Within 2 or 3 months, we should be knowing the outcome of the matter.
Shall I just say 3 months?
Yes, Judge. Yes, my lord. The second point is at the time of filing of heads of arguments, I checked with the Registrar Supreme Court is the position with the petition which has been filed by the applicants with regards to Section 319 judgment, which was not in their favor. And I was told that that petition has not yet been considered. That petition
I was given to understand this morning while I was, just before the court started, that an order was issued.
I checked on Tuesday, so today I did not check, my lord. But if that's the case,
I understand that an order was issued. Mr. Shanghala, are you aware of that?
Indeed, Judge, we received notice on Friday that the petition had been turned down.
You mean dismissed?
Yes, dismissed.
in that case, my lord, then the second point falls away, my lord.
Sorry, that petition was over on what issues?
The petition, he had sought to dwell on two questions of laws which he wanted the Supreme Court to discuss, my lord, to determine on. One of them was issue of whether it was appropriate for this court to continue with the accused persons not having legal representation.
And what was the answer from the Supreme Court? If they
So if the Supreme Court dismissed it, it means that it is appropriate for this court to proceed with them in the circumstances of the matter, to proceed without them having legal representation. And in another way, again, it answers the whole of this application which we are having today for separation of tribes. I will deal with that when I'm addressing the court on the main application.
When maybe do these orders or judgments come on the e-justice?
From Supreme Court, these ones for petitions, they are not on e-justice. They are saved manually.
Is it likely that there was a judgment written?
They don't write judgments. They just write court orders, my lord. And they don't give reasons.
So the dismissal...
the dismissal, it means the Supreme Court is in agreement with the judgment for which was sought to be petitioned against.
Now, just to recap on that, the dismissal of that application impacts on what and what?
It impacts on this application for separation of tribes, because the understanding of the state is that this application of separation of tribes is that the accused persons, the applicants, who are the accused persons in the main trial, have not yet secured legal representation. So they want this trial. They want to be separated from others who have legal representation so that their trial can continue when they obtain legal representation. I think I've failed to summarize what this application is all about.
What else?
Am I now addressing the court on the...
I'm saying, what else? What other impact is that ruling, the dismissal?
The other impact, what my interpretation is that what that dismissal of that application for petition in persons of 319 application dismissal is that the trial, whatever this court was doing, should proceed. The process should proceed.
Yes. Anything else?
For now, that's all, my lord.
So you are certain that there would be no judgment on that point, isn't it?
Yes, I'm talking from experience. I'm not giving evidence, as Mr. Shanghala might want to say. I'm talking from experience. I've seen people who have petitioned. I've even one of the matters in the Avid trial, when one of the accused persons wrote to the Chief Justice demanding reasons for the dismissal of the petition, then the answer from in fact, I have two of them. The other one is State versus Tamba Pillai. They also wrote to the Chief Justice demanding reasons for the dismissal of the petition. And there's a letter from the Chief Justice indicating that the Supreme Court does not give reasons for dismissals of petitions. I can bring copies of those letters.
No, I don't doubt you. I just want to be sure.
Yes.
Because what I wanted to ensure is simply that if there is a judgment that has been produced, I've seen the order.
Yes, the order is sufficient according to the Supreme Court. Yes. No reasons are given.
Okay. So your second preliminary point has fallen away.
It falls away, my lord.
But it was also to say, let's wait. It was also to say, let's wait until the 3-1.
The Supreme Court has dealt with the matter.
Yes.
The Supreme Court has dealt with the matter.
All right.
And we are all in the clear that the petition was unsuccessful, and there's no point of waiting for that on that point, my lord.
So, in view of your submission that we do not proceed, you perceive that this can be for the time being dispose of this application, isn't it? That we don't proceed. We don't hear the application for separation of trials. I'm saying, in your view, it disposes of the matter for the time being, isn't it?
My lord, when the Supreme Court dealt with the petition, this application had not yet been filed. The state is of the view that we should proceed. The state has always wanted to proceed with this matter. I bet that this.
No, what are you saying? I'm talking about what you said earlier, that the state's position is that this application for separation of trial must not proceed until the application challenging the appointment of the presiding judge is finalized. That's your position, isn't it?
Yes, my lord, because that application, the granting, especially the granting of the order to bring that application, brings a new dimension to this matter, which was not there, my lord. Because initially they've been talking that we need to bring this application. Now they filed an application with the High Court. The High Court gave them permission to bring that application. It brings a different dimension to this matter, which was never there before.
My question was simply that, for present purposes, that position of yours would dispose of the need to deal with this application for separation of trials.
Yes, my lord.
All right. Anything else?
Nothing on this at the present moment, my lord.
On the preliminary points, okay. Yes. Mr. Shanghala.
Judge, I'd like to confirm, to start with the confirmation that indeed the petition was turned down. I haven't printed it out. I scanned it and have it electronically. If I get the opportunity, I can print it out and avail it to the court.
No, I got it on my
All right.
smartphone.
Okay. The other issue is, just before I get to the issue of the preliminary issue, is what the 319 sought from the petition sought from the Supreme Court. Three things. One, it sought that the finding that a Section 319 application cannot be brought by way of ex parte application. It sought that matter be reconsidered. Secondly, the finding that the questions of law be reserved only and dealt with at the end and not during or before, that be reconsidered. And three, only 3 questions and not all the other previous questions. The lack of legal representation, whether that amounts to a violation. Yeah, those 2 questions. Those were the issues, and the discovery that was done mid the taking of the pleas. So that was what the petition sought to do. In any event, that's now overtaken by the fact that it has been conclusively dealt with by the Supreme Court.
So just so that we are on the same page, what do you understand to be the answer?
The effect of that, however, is to be found in the heads of Mr. Marondedze. I don't know, Judge, I've given you a file if you have received a copy of the index file.
Yeah, you did a good job, Mr. Shanghala, but I can't have, you see, there is a formal court record here, which must be properly paginated. Then I have got your indexed record, the same documents exactly, you see. I was talking to my staff that what I need is one official record of papers filed by the court, because otherwise I have to be looking to see whether what you filed is the same as what appears in the official record. You see what I'm saying?
Yes,
so I will insist that I just want one set of documents in the court file. Otherwise, I will have this pile by you, this pile by my staff, and perhaps another pile by another one wanting to make an index, and I won't be able to be looking at all that. But anyway, you did a good job with your index.
Thank you. I just thought it had become voluminous, and it's self-contained. But as it pleases the court, I wanted to refer you then, in that case, to page 4, paragraph 2 of Mr. Marondedze's heads.
In which matter?
Where he raises the point in limine. He raised the point in limine only in his heads. They were not canvassed in any of his pleadings. Yes.
You said paragraph?
That's paragraph number 2.
Mm-hmm.
He says, secondly, the applicants have petitioned the Chief Justice. That has been dealt with. And then 2 questions of law are questions 3 and 4, which basically deal with the issue of legal representation and the right to a fair trial. As at the time of drafting these heads of argument, the Supreme Court has not yet considered the petition. The question is, what if the Supreme Court decides in their favor? Does it not address their grievances? So there are grievances. The court has acknowledged that those grievances are the grievances that drive me to make the application with co-applicants in the separation of trial. What it now means is that those grievances are not yet dealt with. They are still alive. I'm in the position I was as if the petition had not gone to the Supreme Court. They are alive. Judge, before I continue with dealing with the application, I'd just like to address some of the issues you've raised with Mr. Marondedze as you were...
So you are saying the grievances you had, which went before the Supreme Court, are still alive. They've not been resolved.
Indeed. It is exactly as...
So what did the Supreme Court do?
It dismissed the petition. It didn't provide reasons. It's dismissed, right? So
what is the effect of the dismissal on your grievances?
The grievances that took me there are essentially the grievances I have.
No, I'm saying when the Supreme Court dismissed your application containing your grievances, where does that leave those grievances?
They remain alive because I do not know.
I don't know. Then you mean the Supreme Court did nothing?
They didn't consider.
What do you mean they didn't consider it? They dismissed your application, meaning to say all the things you were complaining about were not merited.
Let me rephrase. Maybe consideration is the wrong word. The 319 petition was not heard in the Supreme Court. It has a discretion under Section 14 of the Supreme Court Act.
No, that we
to
know
refuse.
is that you went to the Supreme Court with certain grievances.
Yes, indeed.
Were they approved or not? Were they upheld or not? They were dismissed, isn't it?
In the final analysis, I'm exactly where I was before I went there.
Well, that is your understanding. My understanding is that when you take a matter of the Supreme Court and the Supreme Court dismisses your application, it means that you have been unsuccessful.
Yes, you are correct. I have been unsuccessful.
Well, we can't...
But what it means is
Yes.
that Mr. Marandesa says here that he acknowledges there are grievances. He acknowledges there are grievances. When the court adjourned this matter for hearing today, the court issued a ruling in which it also acknowledged that the grievance at the crux of the issue is the lack of legal representation. I'm saying, it having made it or it being pending, I'm still where I am. I still have that grievance. That is why I'm here for a separation of trial. So it doesn't make a difference to this issue. It was only relevant to Mr. Marandesa in making the point that perhaps the court not proceed. That's the only relevance. He can no longer use that point. That's the point I was trying to make.
Yeah, well, he had already accepted that, the second point.
Yes.
Yeah.
Yes. The first point he makes, I would like to inform the court that on Friday we attended to filing the matter. First, one step back. We were granted approval to cite the name of the presiding judge, Moses Hungwe Chinhengo, in an application. That court order is dated 25 October 2024 by Justice Coleman. In the matter that is HC-MD-
well, just go ahead, make your point.
Yes. We thereafter, on Friday, attended to filing that matter, and as a result of some technicalities in the registrar's processes, it was not enrolled. We, this morning, attempted to re-enroll it, and my understanding is that when I left the registrar's office this morning, the registrar staff were re-enrolling it. The mistake...
Yeah, let's not waste time. The state accepts that you have made your application.
Okay. So that is the issue. The application is not for the removal of the judge. It's not as you had stated. It's dealing with the appointment by the president as constitutional. How long will it take?
Well, what is the application about?
The application relates to the constitutionality of the appointment made on the 23rd of April 2023 by the late president when he appointed you as an acting judge. That application speaks to the remit of the powers of the president.
No, I don't mind the detail. Yes. What relief do you want in that application?
That review be a declaration that persons above the age of...
No, what relief do you want?
Yes, a declaration. I seek certain declarations and certain
just
actions
in relation to the appointment of the judge. What do you want to happen?
That it be declared unconstitutional and that the appointment be reviewed and set aside.
Yes, which means the judge be removed, isn't it?
Yeah, well, that's the effect of that order.
Yeah,
but
that's what
the application is not for the removal. I don't know how to...
Yeah, it doesn't matter, but the net effect of it is if the court finds that, well, the appointment was unconstitutional, then...
Indeed, that is the effect.
Yeah.
Yes. How long will it take?
No, before, what do you say to that? The long bit, it doesn't matter. What do you say to their response? That the matter should not proceed?
You see, that application, Judge, does not seek interdictory relief. Okay? So I would like the court to record.
I don't follow. What do you mean it doesn't seek interdictory relief?
As you stated, would we continue until the court determines or not? I could have brought an application saying, pending the determination of this matter, the criminal trial in CC.
Yeah, but Mr. Marondeze talked about prudence, not so much that
Yes,
there was.
indeed.
Yeah.
And I would like it recorded that it is the state that brings the point that this case be further delayed. The same way the state is asking for 120 days, which I know you don't have before you. And if the court is going to hear that matter would only be this matter would only be delayed by 2 months, as he stated. I wanted to correct 3 months. I wanted to correct that. Hence, I was going to that issue to say that there is a period between the 15th of December to the 16th of January.
Well, let's not worry about the period the court will take, because we don't dictate that pace.
Correct.
We know. I was just wanting to know how long does it normally take. It
Correct.
can take more than 3 months.
Correct.
In some jurisdictions, we know that from the date you file an application, an opposed application, within 45 days the matter is heard and finished. In other jurisdictions, it takes a little longer.
Correct.
So that is not the issue of moment now. The issue of moment is, he says we must not proceed to hear your application for separation of trials until that matter is determined.
My understanding of what he was saying was, and maybe this is where I'm wrong, was that pending the determination of that matter, and it is within the context of the word pending that you find the issue of how long.
I'm not concerned about how long. I'm simply concerned about the point he makes that the application for separation of trials must not proceed until the application you placed before the court regarding the judge's appointment has been finalized.
Well, as you know, Judge, there are merits in what he's saying.
So you agree with him?
I agree that if you continue and the court finds in our favor, all of this would have been for naught. The point I want to make is, Judge, that is the point made by the state. Let it not be said that we delay matters. If we wanted to delay the matter, we could have brought an application with an
doesn't matter, Mr. I know it is the state who have said that.
No, it's the state who said that.
Yes,
And that
so
should be on the record.
please, can we deal with the relevant issues?
No, it's relevant to you.
Okay,
Judge,
it's not relevant.
No,
It's not relevant.
Okay, fine.
I am saying that the state has said there must be a delay
Yes.
occasioned by the existing application.
I'm happy that that is the case. I now turn to the application. First, I would assume that the judge has read my papers. Or should I go through the motions? Because it will save us much time but I'm in the hands of the court.
I always read papers.
Okay.
It's a very good assumption. Rather than
Yes.
repeat it, I assume the judge has read. You
I made
must
that assumption,
work on
yes.
the basis that the judge has read.
Yes. So what I intended to do was to address first the issues that arise from the heads of the state.
No,
and then-
he says we mustn't deal with that application.
Yeah. Which is, Judge, you see, that is why I was saying, and I wanted recorded that the state raised the point. We don't object to that point. In fact, they make good points with the point they make. That requires a determination. Once the court has made a determination in that respect, we may then consider everything else. And the reason why I raise that point, and why I raise it to show the link to why the state is not joining cause with us, as they are also obliged under Article 5, is that to continue proceedings in this facility is to continue to violate the fundamental rights of those people. So the state is happy when the rights are being violated, whether there's no legal representation or whatever, but they're not prepared
I'm
to
not
say.
sure I'm following.
What I'm saying is this, Judge.
Well, I'm not sure I'm following. What are you about?
What I'm saying is this, Judge. Article 5.
What point do you want to make?
Article 5 enjoins the state to respect and protect our fundamental rights. One of them is to not be taken through a process that is unnecessary. That I believe to be the case, so that I'm tried by a competent court. That's the point they raise, to say that if the court then finds in our favor.
But you said you agreed with them.
Yes, and now.
You agree with them, isn't it?
I do.
So what is the next point you want to make?
This is a point to you, Judge, to say that is one constitutional aspect. There is another, and that is that those people are being subjected to degrading treatment, contrary to Article 8, for as long as we're in this courtroom. The court should look to that fact to say that the state should also be enjoined to want to protect that fundamental right. Because if I'm being taken through a procedure which is an incompetent procedure, the state is saying don't do that, because if it's then found that it's incompetent, you would have taken us through a procedure which we shouldn't have been taken through. I'm saying the same effect happens if I'm taken through a procedure or somebody's taken through a procedure that is contrary to a fundamental human right. And that is exactly the point. So I'm trying to raise here the inconsistencies of the state and say they blow hot, they blow cold. But this is something that we will determine further, and I will prove to you further from what is on record, what they have said. For example, you may recall, Judge, that it was Mr. Marondeze who first indicated to you and read from that lectern, from a laptop given to him by Mr. Cliff Kuzulwandle Lutibezi, certain cases that you cannot proceed, because if you proceed, a court may come back and determine that the process without legal representation may be set aside. It was him. He has flipped. In soccer, they call it agrukatonyo.
What does it matter?
It matters because what I'm trying to say is...
Mr. Shanghala,
yes.
I've heard his point, I've heard your point, you agree with him,
yes.
I will decide.
Aha. Thank you very much.
Yes.
I was just pointing out the duplicity. Thank you.
Yeah. Today we've had two issues. I'll need a bit of time to decide on the issue whether we continue until the other matter is heard. Unless you had something in reply.
Nothing like that. We are just standing to listen to the court matter.
I assumed that you would have nothing in reply. So let me decide on your preliminary point, and to the extent that it is necessary, decide on your other application for change of venue.
May I request some guidance, Judge? No, this is not asking for legal advice. It relates to my subpoena to go and testify. Should I take it that we will return after lunch and I should make arrangements?
No. You are going ahead. I will need to, maybe we meet next Monday. I will decide on this preliminary issue. If I decide against it, we proceed to hear the separation application. If I decide for it, then it will be that.
As it pleases the court.
So I will adjourn these proceedings to Monday for handing down a judgment on the issues we have. Yes, Mr. Siomui.
I've got nothing to add, my Lord. I was just trying to note down the court's...
Yes, you may sit. So the order is that the matter is postponed to Monday. What is the date? Monday? 18th. Monday the 18th. Or should we make it Tuesday? Monday.
Judge, on Tuesday...
All right, we keep it at Monday. Yeah. Matter postponed to 18 November 24, at 10 o'clock for ruling on applications the usual orders in relation to continued custody. Oh, sorry. Mr. Shanghala was right in a sense. We have other applicants. I can't go without asking them whether they have anything to say. If the next one would be Mr. Hatuikulipi, do you want to make any additions and you come over or what? Yes. You have nothing to add? You want to make some submissions? All right. Yes? Yes. I thought Mr. Shanghala was representing you ably. All right. So the matter is postponed to the 18th of November at 10 o'clock for rulings on the applications I've heard today and the usual orders in relation to the continued detention of accused persons and the continuation of bail in respect of the one or others is made. The court will adjourn.
Yes, court, please.